Hello everyone, welcome to USA State. Today we are talking about something that is causing a lot of anxiety right now in the immigration community, and that is the possibility of family green card priority dates retrogressing in June 2026. Now before you panic, I want to be very clear about something. If you already have a green card, nothing in today's video affects you. Your status is not being taken away. What we are talking about today affects people who are in the process of waiting for a family-based immigrant visa or who are about to file for their green card. And if that is you, this information is critically important. We are going to break down what retrogression actually means, who is specifically at risk, what you can and cannot do about it right now, and what the real-world impact looks like on your timeline. If you are interested in this topic and liking this video, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's start with the most important question, because a lot of people misread headlines about priority dates and immediately fear the worst. Retrogression does not mean your petition was denied. It does not mean you lost your place in line. And it absolutely does not mean that someone is taking your green card away. What retrogression means is simply this. The cutoff date published by the U.S. Department of State moved backward. And because of that backward movement, people whose priority dates were previously current, meaning they were eligible to move forward in the process, are now no longer current until further notice. Here is what you need to know about how the system works. When a U.S. citizen or permanent resident files an I-130 petition on behalf of a family member, that family member receives what is called a priority date. That priority date is essentially their spot in line. Every month, the State Department publishes something called the Visa Bulletin, which sets cutoff dates for each immigrant visa category. If your priority date is earlier than the published cutoff date, you are considered current and eligible to either file for adjustment of status here in the United States or move forward with consular processing abroad. If retrogression occurs, the cutoff date moves backward, and people who were just about to become current must now wait longer. In a recent development, immigration analysts and legal observers have been closely watching the June 2026 Visa Bulletin data, and the signals are pointing toward possible retrogression across several family preference categories. This means that thousands of families who were expecting to file or move forward this summer may suddenly find themselves waiting again. According to sources tracking Visa Bulletin trends and the State Department's published demand data, the categories most at risk include the F2A category, which covers spouses and children of lawful permanent residents, the F1 category covering unmarried sons and daughters of U.S. citizens, and the F3 category covering married sons and daughters of U.S. citizens. These categories have historically experienced high demand relative to the annual visa supply, which is what drives retrogression in the first place. Now let's talk about who specifically is affected, because not everyone in the family immigration pipeline feels this the same way. If you are the beneficiary of an approved I-130 petition and your priority date has not yet become current, retrogression does not change your situation at all. You were already waiting and you continue waiting. If your priority date was current and you were in the middle of consular processing, meaning your case is at the National Visa Center or you are waiting for your interview appointment at a U.S. embassy or consulate abroad, retrogression can potentially pause or delay the scheduling of your immigrant visa interview. Reports suggest that in past retrogression periods, the National Visa Center has slowed down document requests and scheduling for cases in affected categories. That is a real and frustrating practical impact. The group that faces the sharpest and most immediate impact is people who were planning to file for adjustment of status, which is the process of applying for a green card from inside the United States using Form I-485. In order to file an I-485, your priority date must be current according to either the Dates for Filing chart or the Final Action Dates chart in the Visa Bulletin. If retrogression hits before you file, you simply cannot submit your I-485 until dates advance again. Let's put this in perspective with a concrete example. Imagine a green card holder who sponsored their spouse through an I-130 several years ago. That spouse received a priority date of, let's say, early 2022 in the F2A category. For months, they have been watching the Visa Bulletin, and the cutoff for F2A has been inching toward that date. They were expecting to file their I-485 this summer. If retrogression pushes the F2A cutoff back by even a few months, they are stuck. They cannot file. They have to watch and wait again. That is a real family, real stakes, and a very real frustration. What makes this particular moment worth paying attention to is that retrogression in the F2A category is especially significant because the F2A category actually has no per-country annual cap the way the employment-based categories do. However, it does have an overall annual numerical limit. When demand spikes, as it has been doing due to backlogs that built up during the COVID-19 years, the available visa numbers get consumed faster than the fiscal year can replenish them. Immigration experts note that the overhang from delayed visa processing during 2020, 2021, and 2022 continues to ripple through the system in 2026, creating demand surges that the State Department must manage by pulling cutoff dates back. Beyond the immediate filing impact, there are broader practical concerns. For people in the United States on temporary status, for example, an H-1B or a work visa, who were counting on having their I-485 filed to maintain work authorization or to qualify for extensions beyond 6 years, a retrogression can create real legal exposure. If you cannot file your I-485 because dates have retrogressed, you lose access to I-485-based benefits like employment authorization documents and advance parole. Legal analysts suggest that anyone in this situation should speak with an immigration attorney as soon as possible to evaluate their options and protect their current status. Here is what you can and should be doing right now if you think retrogression may affect you. First, check the most recent Visa Bulletin immediately. The State Department publishes it monthly, and you can find it on travel.state.gov. Second, check both the dates for filing chart and the final action dates chart, because USCIS sometimes allows applicants to use the earlier dates for filing chart to submit I-485 applications, even before the final action date is current. Third, if your priority date is anywhere close to the current cutoff, and you are eligible to file, speak to an immigration attorney about whether filing now before potential retrogression hits is an option. There may be a window. Fourth, if you are at the National Visa Center stage, make sure all your documents are submitted and complete. NVC completeness can help your case move forward even in a challenging environment. Advocacy groups warn that retrogression disproportionately impacts families who have already waited years, sometimes over a decade, and who are now facing yet another delay through no fault of their own. The administration has not indicated any intent to request additional visa numbers from Congress to ease these bottlenecks, and there is currently no legislative movement that would significantly change the annual visa caps for family categories. That said, the Visa Bulletin can and does improve in some months. Retrogression is not always permanent, and the October start of a new fiscal year often brings renewed visa numbers and movement in cutoff dates. To summarize, the potential June 2026 retrogression for family preference categories is a serious development for families in the middle of the immigration pipeline, particularly those in the F2A, F1, and F3 categories who are approaching the filing threshold. It does not affect approved green cards, and it does not mean any petition has been denied. But it does mean delays, and for some people in temporary status, it may create real legal urgency. The most important thing you can do right now is know your priority date, monitor the Visa Bulletin every month, and consult with a qualified immigration attorney if you believe your case is at risk. That is all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we will see you in the next video. If you have not subscribed to our channel, please subscribe to the USA State Channel for more U.S. immigration update videos.